Alright, pretty eye, goddamn. Goddamn, sooner or later, I'm gonna have a goddamn pretty eye me take though. I can't deny her though. They my bestie. She's my bestie. That's my bestie. Your pair of eyes had me paralyzed. Toxic nigga, but you made me to a better guy. Smoke, but with you on forever, ever. I can watch you all day, girl, like you televised. You think like this nigga, they ain't never lied. I left the bitches alone, I had to pick a side. Look in your eyes, girl, you were hypnotized. Of course it was your breasts, hips, and them damn thighs. Close my eyes, I'm still mesmerized. Get mad at my bestie, I tried. That's my bestie. My pretty.
I heard she's the one, she's got it going on. That's my pretty eyes, baby. Yeah, yeah. She don't take no mess. My bestie is the best. That's my pretty eyes, baby. Yeah, yeah. I heard she's the one, she's got it going on. That's my pretty eyes, baby.
Hey, what's up? Hey, Daniel, happy Saturday to you as well. I hope you enjoyed your birthday. Anyways, so YNWMELLY's ex-girlfriend went to court on Tuesday or on Friday, and I didn't get to see it, so I'm watching it today. What's up, Tammy Lynn? So I figured I would share it and react to it with you. So here we go. Also, they're doing a couple motions. There was another guy there that was kind of weird, but anyways, okay. Let me see. Hold on. Let me make sure I go down here. Okay, let me make sure this is full screen. Okay. Thank you, Tammy Lynn. I appreciate that, hon. Okay, let's start.
So you ready for me to go back around with you? Ready, sir? Yes. Okay. Your client is present? Yes. Miss Hamilton, where are you at? Right there. Come on up. All right, Mike, you good? Okay, let me go back on the record. This is actually on the top of page 2. The case is turned out of state versus Jamell Devins, 19-1872 CF10A. The reason that we're here today, this is an emergency motion to vacate, which is filed on behalf of Mariah Hamilton, who is a material witness in the case. Can I get the lawyers to announce their appearances for the record?
Yes, Christopher Barris for Ms. Hamilton.
Justin Griffiths, on behalf of the state, and joining us on Zoom are Ms. Buckaloo and Ms. Collins.
All right, I got them both on the call. So, counsel, I did read the emergency motion to vacate, which was electronically filed February 17th. I likewise read the statutes and the authorities cited therein. So, any evidence, witnesses, or testimony that you'd like to present? Go ahead.
Not at this time.
Just your argument?
I think the court can decide based on my pleading.
Okay. So, Mr. Griffith, let me ask you, since you're the one that's here, the state's position on the defense emergency motion to vacate, they want me to take the ankle monitor off Ms. Hamilton.
No, Judge, they would be objecting based upon the fact that the writ was issued in the first place and the difficulties in securing her presence for trial.
You can't force somebody to testify that doesn't want it to be wanting to testify. I don't care who you are. Like, you should never have to force anybody to testify. You should be able to make your case without them, if that's the case. Why is her... It just irritates me, but anyways, okay, we're going to continue because both her and her mom are on an ankle monitor because they don't want to testify, but she can still plead the fifth. So what is that? Like, what are you doing?
Okay, so listen, again, not that I'm certainly not foreclosed to reconsidering this at a later point in time. And for the record, I did read the motion, and there's a lot in here about 942.03. Mr. Barrett's position is that that's not applicable to Ms. Hamilton, and he's probably right about that. That's why I released her from custody the first time that I saw her. However, I did look at everything in the electronic docket. I was not the trial judge back then handling this case. I'm not making any judgments or finding any facts about it. But there does seem to be an awful lot of pleadings, emails, letters, pleadings, notices, that there were some issues going on about cooperation with witnesses. So there's an easy way to do this, and there's a hard way to do it. It would appear the prior judges that handled this case came to the conclusion Ms. Hamilton chose the hard way to do these things. I don't think anyone that's not charged with a crime should be under any form of security anyway under normal conditions. However, this isn't a normal condition. The state's identified her as a material witness.
Okay, but if she doesn't want to testify, you should not make her. You're only making her a material witness because you want to.
I do have 902.15. Again, this is only applicable when someone is facing life imprisonment or the death penalty. Mr. Devins is in fact facing the death penalty. All she, just like any other witness, has to do is come to court. And either side wants them to come to court to a deposition, to a motion, or to a hearing. And as soon as that responsibility is concluded, that will end the security that's been put in place, which I have chosen to be an ankle monitor as opposed to posting some form of monetary bond. So at this point, respectfully, I'm going to deny the emergency motion to vacate. It's going to stay right the way it is.
He's on trial, not her. He's on trial. This is what I don't get. This is what happened in the YSL trial too. They force people to testify and then they give them immunity and all this other dumb stuff. So they have to freaking testify, which is not okay. Like, they should not be forced.
And again, I'm not foreclosing either side on whatever motion in the future. If you want to need time for an evidentiary here, I'm happy to do that. And again, I'm always ready, willing, and able to listen to any evidence, witnesses, or testimony that either side wants to present regarding the issue. But based only on what I've read in the electronic docket and what's been in the pleadings, because that's the only thing that's been presented to me, I'm just not comfortable doing anything else at this time. So that's what I'm going to do.
Your Honor, I don't understand where you're deriving your authority from. Can you explain that for the record?
Well, I mean, actually, I usually don't have to answer lawyers' questions, but this is security. Security is ankle monitor. The alternative would be, do you want me to take the ankle monitor off, put her back in jail, and set a monetary bond for her to post? Is that what you want me to do? Because that's what security means in the statute, just like any other bond statute. So that's where I'm getting the authority from, sir. 902.15. So I'll enter the appropriate written order. Again, Ms. Hamilton, same as when I met you before for the first time. If any side subpoenas you to testify at a deposition, at a hearing, or a trial, whoever that may be, state or defense, all you gotta do is show up, honor the subpoena, and then as soon as the trial is over and the matter is resolved, we will also resolve your current situation. Anything else I can do for you?
No, Your Honor.
State, anything else I can do for you?
Yeah.
Okay. So, Mr. Devins, all pending motions are set April the 1st at 1:45 p.m. His trial remains set September the 10th at 9 o'clock. So I believe that concludes FT for this morning. However, we are going to handle one matter on the FG docket, which is State versus Willie Ward, 15-10015 CF10A. So as soon as I have him present, I have all the parties present for that. We'll go back on the record, so we're going to be in a recess until we're ready to go forward with that.
I don't know what this is. This is attached to Melly for some reason. I don't get it. That's her mom right there, and her mom's on ankle monitor as well.
May we be excused?
Yep. See you next time.
Okay, this kind of confuses me because they all stay in the courtroom. Okay, let me talk about this for a minute. We'll wait till they come back. Hey, James, how are you? So.
Good morning, everybody.
Oh, they're back on the record.
Good morning, Judge.
Good morning.
Good morning.
Mike, this is not quite on the record, okay? Ms. Buckley, I'm not on the record yet. Can you, is that you on Zoom? Hold on, we'll turn it on.
Judge Perez is here.
Yeah, bring it. Okay. Ms. Buckley, can you hear me? Okay, so I got Mr. Griffiths in person.
Oh, I'm sorry.
I have to let people in one at a time. So I need to handle this. He's here. I'm gonna get his order. Ms. Collins, I'm not on the record yet. Is he on the Zoom? Can you hear me?
Okay, I'm wondering if this has to do
Let
with
me handle
his
one other
witness
matter, and I'm gonna
tampering
be
case.
right with you, okay?
If this is the one that mentioned all the crap that Melly was doing in jail. I'm gonna have to look into this case.
There's people, I'm not quite on the record yet. I see on the Zoom call. Can you hear me?
Yes, I can hear you. Good morning.
Okay. There's people, am I waiting? I got Ms. Buffalo on Zoom as well. Am I waiting for anyone else regarding Mr. Perez's hearing this morning?
No, the teams, we're all out of town right now. So
It's okay, James.
Okay, understood. All right, so, Mike, you good? Okay, so let me go on the record. This is the bottom of page 2 of Wesley Perez. Mr. Perez, how are you doing this morning?
Good, how are you?
Good. All right, I got Ms. Buffalo on the Zoom call for the state. I've got Ms. Peoples on the Zoom call for Mr. Perez. So this is on for a couple things today. The easier one, let me just do that one first. Ms. Peoples, I got the defense motion to file ex parte motions for costs and investigations pursuant to Andrews versus State. So I did read the motion. Listen, I do that all the time, but I just do it on a motion by motion basis. I know that I crossed out the ex parte on your all's last request because that was just it was just money for an investigator. But if you all submit something that's fact specific or in preparation of mitigation, that type of deal, I sign those ex parte all the time. Okay, I just do it based on what's being requested. So that being said, anything you want to tell me? Go ahead.
That's why we filed this. I'm sorry, Ron, go ahead.
No. I mean, listen, I'm happy to listen. I think what you're asking is for is a blanket order that says you want all these motions to be ex parte. I'm going to deny that request because, again, I just do them based on what's being requested. And if it's a generic thing for money, I just don't see any reason why that has to be ex parte. I don't think it's a secret that you're going to have investigators. But if it's anything specific, anything related to the preparation of the defense, whether that be guilt phase or penalty phase, anything related to work product, then not only will I sign it ex parte, just send it to my office with JC's response and a proposed order. I will also enter a separate order instructing the clerk that this is all sealed and it won't be available to public record. So does that resolve your problem, whatever you need?
No, because you're denying, okay, because this, even what we already have filed are mitigation, meaning the investigator and the mitigation specialist. So these are like, in its totality, the state doesn't need to know unless we're actually placing them in evidence or putting them on a witness list. So it doesn't resolve the issue, because the only reason we're doing, we have to go to the court to get the order to get to the JAC.
Yeah.
So this whole issue of what we're spending money on or seeking money on, the state shouldn't be a party to that
Okay,
at all.
I understand your
It's
position.
kind of, when you're saying you're denying it, you're kind of putting us back where we're starting in the.
No, I'm just denying what you're asking for today. You want to buy, the end of your motion says you want an order that's permitting you to file ex parte motions for costs and investigations. I'm denying it because, again, not to repeat myself, but
Everything
whatever
is
you're
cost,
asking
all the
for is
doctors
what
are
I'll do.
costs, all the experts are costs, they're all costs.
Right, but you haven't done it, you haven't done any of those yet. It's just, this has just been for an investigator, so, which I signed.
Yeah, but the investigator is also work product, because we haven't listed it.
I respectfully don't agree with you. You gotta do all those things pursuant to the ADA guidelines. It's not a secret that you're doing them. You have to do them to handle these cases. So.
See, this is why I'm confused. Are they part of it or what is going on? Like, I don't understand this. Like, they bring in that other dude and then they're talking about all this other stuff. And I don't know if this
I just
is
don't see
another
it that way.
case.
But I understand your position, but I'm gonna deny that motion. I'm not doing the appropriate written order, but again, whatever you submit to my office, if it's something that needs to be ex parte, I won't cross out those two words and I'll handle it accordingly. Next,
So,
yes, ma'am.
just to be clear, I'm trying to belabor the point. So if we file ex parte for costs in the future, you'll grant it.
Depending on what it is.
All right, so the motion's denied, I understand.
Okay, next one is a defense motion to compel discovery. That was electronically filed February 4th, 2025. There's 5 pieces of evidence that I guess require some type of download. Then there's 1, 2, 3, 4, 5, 6 witnesses that you're looking for better addresses for. And then it looks like you're asking for a replacement of a video that.
See, like all his family's still there, but I'm still not understanding. I don't know if this is the motions that they were supposed to finish and Miss Buckley wasn't there because she had her baby or whatnot.
Is unable to be played. So let me take those in those 3 groups. Ms. Buckley, as far as the 6 witnesses that they're asking for better addresses for, which is Carmela Mauro, Mauro, Christopher Williams, Gloria Crespo Calderon, Daniel Lorenz, Lorenz, Scott Karras, Carris, and Michael McKay, Mckae. Ms. Buckley, does the state have any objection if I grant that? Give you 30 days to give them the best address you have, or if you don't have any better address, to file something that says that's the best address that we have. We don't have anything better.
Hey, bro.
No, Your Honor, I have no objection. I already have, the detective looking into it for me because I know both of them work for the police department. It's not my investigation team that will get on it. So that, I have no objection to that. At
Okay,
all.
so that, we'll include that in the order. Those requests are going to be granted as to all 6 of those witnesses. The state's going to have 30 days to provide a new best address that they have for each witness, and if they have no better address than what has been previously supplied, you have to file something that states that as well. Ms. Buckley, regarding the 5 items that are subject, I would suspect subject to downloads, a USB from a black backpack, MacBook removed from Exhibit 84, that's the backpack, network video recorder, which is labeled Exhibit 132, DVR with power supply and remote, which is labeled Exhibit 134, and iMac computer desktop, which is labeled Exhibit 136. They're certainly, I guess, entitled to these things. So what's the status of the download on these?
Bro, I would like to explain what is happening, but right now I'm freaking confused. Okay, so they had Melly there, and then they said that they were going into recess, and that the other motions hearing ain't till April 1st or whatever. But at the same time, like all his attorneys, all his family's still there. His ex-girlfriend's still there. I don't know if this has to do with the tampering case. I don't know what this has to do with. I don't know if this is like them talking about the evidence they still need, downloads of phones. I'm so confused. I'm so confused on this. Like I don't know.
When we did an evidence review last year with the defense, those items had not had search warrants on them, either because they were not of evidentiary value to us, or we didn't think there was anything on them. And we had asked for the defense to see if they could get consent from their client. We didn't have to go through doing warrants for all of them. They informed me, in the last couple months that they could not.
Why would the defense, why would their client want to fucking help you in any way? Why would they want? I guess if you're I don't know, but man, I would make you work for it too. Anyways, okay, right.
I get consent from their client, so I have to discuss with the detective whether or not we're going to even do warrants on those items. If we do, obviously I'll provide them. I've already reached out to the detective to see if anything was done on those items. If not, I'll file something that says nothing was done on those items.
So when you say nothing was done, you mean it's not something that you're planning on using at the trial?
Correct. A lot of these items, we downloaded a bunch of things, phones, social media, things of that nature. These items were either under a bed, off, not things of potential evidentiary value. I'm not sure. I have to discuss with the detective whether or not he wants to go forward with a warrant on those items. Now that we don't have to.
Okay, so Ms. Peoples, let me ask you this, because I'm inclined to grant your motion, give the state 45 days to produce whatever gets downloaded from this. If they decide not to download things, do you want the authority or an order from me that you can have your own person come and download whatever you want?
Right, and I apologize to the ASA. I wasn't directly involved, but I am aware of this part of the conversation, and that was not, it should have been in the motion, regarding the issue of getting consent for warrant. What I would ask.
I'm so confused. I don't know who that defendant is. I don't know what the fuck this is about. I don't know why Melly's lawyers are still in the courtroom, why his family's still in the courtroom. I have no idea, unless this is part of something else, like the conspiracy. I am so freaking confused.
The alternative is if the defense could have our own expert go to the evidence and download independently.
All right, Ms. Buckley, any objection to that?
No, Judge.
Okay, so listen, on those 5 items, the defense motion compels granted. The state's gonna have 45 days to turn over anything that they download. Or Ms. Buckley, if you could just put something in writing, I'm just picking one, for example, with item B, the MacBook removed from exhibit 84, which is exhibit 87. If you all decide that you're not gonna download anything from that, just put something in writing, we're not downloading anything from the MacBook. And then the end of the order is gonna be that the defense is authorized, make an appointment with the appropriate evidence person, and their own expert can come and download whatever they want from those items. We won't include that language in the order. So, Ms. Peebles, I think that leaves, you got one thing, an MP4 video. This looks like something that probably came from evidence.com, and it's not viewable, so you need another link to try to download it again. Is that what you're looking for?
Yeah, it was received, but we're having no ability to actually view that item. So I guess this point would just be a new copy that's actually viewable.
Ms. Buckley, is this 5-Miranda.mp4? Is that on evidence.com or is it something else?
I would have to double check this on evidence.com, Your Honor. I know it was during COVID when the case happened. So if not, I will email them a link that I'll create myself.
Okay. Okay, so for that one, that
See, I mean, this is his attorney. I don't know who the fuck that is, but they're still all at the damn table. I'm so
request
confused.
likewise is granted. I'm gonna give the state 30 days to either produce a new link or to produce a new copy of the video. So it's 30, 30, 45, and then they can use that next week.
I mean, that's his other attorney. See, I'm just so confused.
So we're gonna enter that order here and outside. Mr. Perez's trial date remains set right now, May 27th. Oh, Mr.
Matter of fact, I think, okay, this Perez person has nothing to do with the case. I think the reason why these guys are there is because they're supposed to be doing an in-camera review of an in-camera. Okay, last motions hearing, they were supposed to do an in-camera review of downloading the victims' phones. So maybe that's why they're there, is for that reason. And the judge is like there to coordinate, because these guys cannot get along. The state and the defense can't get along. They're filing charges on his girl attorney, or not filing charges, but they're investigating her, right? So I don't know why the hell they kept this going, because her hearing was only like 10 minutes long. And then now this is all BS. And then they're going to come back on record for him, but they're not televising it because it's supposed to be a private showing. Anyways, because it has to do with evidentiary value, whether the state feels like it's important or not. It's the victims' phones. You got to see if they had any beef with anybody. You got to see like if anybody was threatening them. Like, how can you just assume that it was one person? I get, okay, he looks guilty. Yes, the whole scenario looks guilty, but you can't tell me that you didn't look into phones when there was a mysterious text about somebody gonna catch. I don't know if it was Melly or somebody else. They were supposed to meet up with somebody. That's the whole thing. It's just weird. Anyways.
It says May 27, 25. His trial date's May 27, 26. May 27, 26 at 9.
How come his trial is before Melly's? That's weird. Anyways.
People, anything else I can do for you this morning regarding Mr. Perez?
No. John, I couldn't hear the end there. Were you saying 2027 or
26. His trial, I already sent you a trial order.
Oh, the trial ain't till 2026? That fucking sucks, dude.
It's May 27th, 2026. Ms. Buckley, anything else I can do for you regarding Mr. Perez this morning?
I apologize, John. There's something going on with the audio. I couldn't hear you.
Can you hear me now?
Yes.
All right, Ms. Buckley, anything else I can do for you this morning regarding Mr. Perez?
Yeah, Your Honor.
Okay. Okay, so Mr. Perez, if your lawyers need to get you in front of me prior to that trial date, they know how to do that, sir. I'm here every single day.
All right.
Okay?
You're not leaving, right?
Say it again?
You're not leaving, right?
Yeah, I know I look old. I'm old.
No, but there's like-
I'm not leaving.
Maybe I was saying that they're going to be judged.
No, this is it. I'm not going anywhere, sir. I get to sit here for 22 years.
All right, cool.
As long as the voters allow me to keep the job, so.
All right, have a nice day.
See ya. Okay, that leaves Mr. Demons on the top of page 2, so quick recess. As soon as I get Mr. Demons present, I've got all the council present. I've got Ms. Buckley, Ms. Collins on Zoom, Mr. Griffiths here in person. I've got council for Ms. Hamilton present. As soon as I get Mr. Demons, I'll be right with you. We'll be in a quick recess until then.
See, they bring him back out. But you don't get to see the rest of this, which is dumb. And I know it's because it's supposed to be a private showing. I know that they're like downloading the victims' phones. I do know that. Let me just remove you. They're downloading the victims' phones and everything like that. So it's just, that was so confusing. Like, hey, law and crime. Like, you could have done without all that bullshit in between. But so I'm sorry, guys, that you guys got confused. I was confused too. I was trying to think, you know, are we were we doing the same or what, you know, like, my hair is acting weird. If it was the same try, like if it had something to do with him, but it obviously didn't. And then they came back on record, but they went silent because it's supposed to be um a Zoom meeting, basically, of them downloading the victims' phones. So that's that. Because the state wanted to say, oh no, you know, they don't need it, we don't need it, they don't need it, it's not evidentiary value, or there's no need to, you know, it's the victim's phones. Well, yeah, it's the victim's phones. You damn right you should download them. How do you not know that there wasn't somebody else after them? Like, you're accusing one person and one person only, but yet you're not looking in to see if there's anybody that could have been targeting them. That, you know, I mean, you're just blaming him because he was in the car. And I'm sorry, like, with the shot, with, okay, the way I look at it is, in case some people look at it different than I do, but you know, they say 3 feet. 3 feet he got, and then he had some soot around his cheek, right? Well, how do you not know that when they shot through the back, he wasn't turned like this and they shot, and then, but the glass particles and all that singed him, and then, you know, how do you not know? How are you so certain that it came from Melly? How are you so certain? That's my thing, is I couldn't be on a on a on a jury, because, baby, I'm telling you what, I think totally different. Like, I don't get my feelings involved. I look straight at the facts, and I'm sorry, but the only time they said, I mean, they, when even the shots, like from the ranges that they were saying, they didn't know a height. They said it was from anywhere from 5'2" to like 6'4" or somebody, and then all of a sudden, oh well, we know the exact height once we got it from Melly and his co-defendant. What? No. That doesn't even sound right. It sounds like you targeted them. But anyways, and I think it's messed up because, you know, the police, that they get jaded. Like, they get jaded on this whole thing. Because they believe the state, and it shouldn't be about that. It should be about getting the right person that did it behind bars, not just somebody you think fits the bill, or somebody that because they were in the area, or all this other stuff. I just, I don't get it. Anyways, all right, so, well, that was that. That's the end of that. So they're not letting her out on the ankle monitor. They're saying, like, she's got to stay on ankle monitor because they got to secure her testimony. I feel like it's wrong. If she doesn't want to testify, she shouldn't have to. And then they said, oh, well, if they get on the stand and they want to plead the fifth, then they can plead the fifth, but outside of the presence of the jury, and then we'll let them go. Okay, well, when she tried to do that last time, she was forced to testify. It's not okay. Like, you shouldn't force somebody to testify if they don't want to. And then you automatically assume that it's witness tampering. You know, some people just don't want to mess with the freaking law. Some people just don't want to be involved. But you make them involved. It's not okay. And you're the only ones that and you get away with it because you're the state. That's not okay. Come on. When all doubt or any doubt should go to the freaking defendant, shouldn't go to the state. Make the state prove their case beyond a reasonable doubt. And the reasonable doubt is, could they have committed this crime? Could they not have committed this crime? Does all the evidence point to them? Or could somebody else be doing it? You get what I'm saying? So I just think we need to start holding them to the standard that they're supposed to be held in. And that's beyond a reasonable doubt. But all right, Kay, that's the end of Melly's little thing. Other than them doing the download in front of the judge because because there is no he's surprised that they didn't even this is what this judge is. He's surprised that they didn't have it downloaded for the first trial. He was like, you guys already went to trial on this and it's never been handed over? No, it's never been handed over. No, they don't even care about the plea deal because they want the death penalty. They want the death penalty. I mean, they waited till the new law where you don't have to unanimously agree. You only have to be 8-4 for someone to get death. They waited to do that to put him on trial. Not okay. Not okay. Because they should have did that with Nicholas Cruz. I mean, to be honest. I mean, he went in there and shot up the whole damn school and took, a lot of people out because of it. So that's the only time that should have applied was with him. But all right, I'm out of here. Thank you all for supporting me. Thank you. Hopefully I'll keep getting better and better at this. I know I'm all over the place. That's just my mind because I try to think of everything I can at one time, and yeah. But I appreciate you being confused with me. I didn't understand what the freak was going on, but all right. We worked it out, right? All right. Everybody have a blessed Saturday, and I'll probably see you around somewhere.
Turn me up, AV.
Put your eyes on me, yeah, like the spotlight. Recognize me showing love, then got my grind right. Ain't never since day one to love it on side. And since you got my back, I got your back for life. Yeah, pretty honesty. Know just what it is, I got it on me. And you hold me down, you like my homie. Just know I got you down, just what it gon' be. Definition of bestie, definition of friendship, definition of rider, definition relentless. She's a strong woman, she's a sweet lady, she's a great mother. Your pain get aching. Yeah, I made that girl on YouTube. She never dims my light or put me in her dark mood. And I thank you, you appreciate it. You're my favorite girl on YouTube, and I can't fake it. You still got faith in me, make me feel like big. DJ Khaled voice, pretty hot. You still got faith in me, make me feel like big. DJ Khaled voice, pretty hot. Yeah. Met a little shawty. Don't on this show called BDP, you know what I'm talking about? Shit. We been cool ever since, my nigga, know what I'm talking about?
Put your eyes on me, yeah, like the spotlight. Recognize me showing love, done got my grind right. Ain't never since day one the love been on sight. And since you got my back, I got your back for life. Yeah, pretty honesty. Know just what it is, I got it on me. Hey, you hold me down, you like my homie. Just know I got you down, just what it gon' be.